This hearing will come to order. Today we're considering 4 nominations. Tovah Calderon to be an associate judge on the District of Columbia Court of Appeals, and Rupa Ranga Putagunta, Kenia, Seoane Lopez, and Seoane Staples to be associate judges on the Superior Court of the District of Columbia. Certainly welcome to each of our nominees and to your family members who are joining us here today. Thank you for all of your previous public service and your willingness to serve in these very important roles. You have each been nominated to serve in critical roles in the unique justice system right here in our nation's capital. As judges, you will decide matters that impact the freedom, the livelihoods, and families of many individuals who will come before you. I am pleased, certainly, to have 4 well-qualified nominees before us here today, each with a long-standing commitment to public service. Throughout the nomination process, this committee has heard nothing but praise for your legal abilities and for your professionalism. Today's hearing is an important opportunity for me and my colleagues to ask questions about your qualifications, and I look forward to hearing more about how you plan to serve. I will now recognize Senator Langford for his opening remarks.
Chairman Peters, thank you. Thank you to the nominees appearing before us today. It is a long process to go through this to be able to get to this spot. You didn't do it alone. Obviously, your family walked with you through this, and we very much appreciate you going through that process and all your family walking with you. The committee does take D.C. judicial nominations very seriously. Quite frankly, that's a responsibility set to us by the United States Constitution. It is very different than an Article III judge and other federal judges, but it demonstrates the unique responsibility and relationship that the Congress has with the District of Columbia. Part of that responsibility is outlined in the Home Rule Act, which ensures the district has very well-qualified judges to be able to serve in the city. It becomes especially important when we watch what's just happened in D.C. over the past year. Local news media has been filled with reports detailing the rise in violent crime, particularly in homicides across the city. D.C. homicides rose 19% from 2019 to 2020, and is currently up 12% this year. That makes it very important that this committee continues to be able to work towards getting unbiased, qualified judges to bring justice to the criminals and to the victims of crime. I thank this committee and Senator Peters for your leadership in holding this hearing. We held quite a few hearings in the previous 2 years as well, and so thank you for all of this and look forward to the ongoing dialogue today.
Thank you, Senator Langford. It is the practice of this committee to swear in witnesses, so if you will all stand and raise your right hands, including those who are joining us via video. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Our first nominee is Tovah Calderon. Ms. Calderon is currently an acting Deputy Assistant Attorney General in the U.S. Department of Justice Civil Rights Division. She has served in the department since 2001 and has held several leadership roles in the appellate section of the Civil Rights Division. During her 20-year tenure at the Department of Justice, Ms. Calderon has also served on details to the White House Domestic Policy Council, the Civil Rights Division Policy Strategy Section, and the Senate Judiciary Committee. And notably, Ms. Calderon is also a graduate of the University of Michigan. Go Blue. Ms. Calderon, you may proceed with your opening comments.
Good afternoon, Chairman and members of the committee. I'm honored and humbled to appear before you today as you consider my nomination to be an Associate Judge of the District of Columbia Court of Appeals. I would like to thank you and your staff for holding this hearing today. I also would like to thank the D.C. Judicial Nomination Commission and its chair, Judge Emmett Sullivan, for recommending me to the White House. And of course, I would like to thank President Joseph Biden for nominating me. I am also grateful to Chief Judge Anna Blackburn-Rigsby and the other D.C. Court of Appeals judges for their kind words, guidance, and encouragement as I have gone through this process. I would not be here today if not for the love and support of my family and friends. I would like to acknowledge my parents, Stan and Marlene Calderon, as well as my brother, Michael Calderon, his wife, Julie, and their 4 children, Alexis, Andrew, Teddy, and Olivia. They are supporting me today from their homes in Chicago, just 2.5 hours from where I grew up in Northwest Indiana. I also would like to acknowledge my many aunts, uncles, and cousins, as well as the countless friends and colleagues who have supported me over the years and who are cheering me on today. And I have one of them here today, if you don't mind, my good friend Kendra McLaughlin, who I've known since I was 6 years old. I'm truly fortunate to have so many good people in my corner. Finally, I would like to take a moment to thank my best friend and husband of more than 14 years, Gregory McCampbell, and he's here today as well. Gregory has served our country as a member of the military and now as a federal civilian employee like me. He inspires me every day to work hard and to be a better person, and I am forever grateful for his unconditional love and support. I grew up in the Midwest and moved to the District of Columbia in 1995. Following graduation from the University of Michigan, as you acknowledged, I came to DC for a summer internship, but immediately fell in love with the city and decided to make it my home, which it has been now for the last 26 years. As a student at Howard University School of Law, I interned at the DC Public Defender Service and also worked as a student lawyer in the school's criminal justice clinic, where I represented indigent individuals charged with misdemeanors in DC Superior Court. After graduation, I served as a judicial law clerk for 1 year in the U.S. Court of Appeals for the Fourth Circuit. Since then, and for more than 20 years, I have proudly represented the United States in the enforcement of federal civil rights laws at the Department of Justice. I currently serve as an acting Deputy Assistant Attorney General in the Department's Civil Rights Division. But most of my time at the department has been spent in the Civil Rights Division's appellate section. My practice in that office has been extraordinarily broad and has included both criminal and civil cases. I have handled appeals at every stage of appellate litigation and in almost every federal circuit court in the country. I also have had the privilege to work closely with the Office of the Solicitor General on cases before the United States Supreme Court. Although I started in the appellate section as a line attorney, I eventually worked my way up to the position of deputy chief, with responsibility for supervising the work of more junior attorneys and helping to manage the day-to-day operations of a busy office. My career in the Civil Rights Division has provided me with a deep appreciation for the rule of law, and I am grateful to each and every one of my colleagues over the years from whom I have learned so much. An express part of the department's mission is to ensure fair and impartial administration of justice. This responsibility is unique to lawyers representing the United States, and I believe it has prepared me well for a career on the bench. If confirmed, I will work hard to ensure the fair and impartial administration of justice for my fellow residents in the District of Columbia. Thank you again for the opportunity to appear before you today, and I look forward to answering your questions.
Thank you, Ms. Calderon. Our next nominee is Judge Rupa Puttagunta, who currently serves as an administrative judge for the D.C. Rental Housing Commission, where she is responsible for ensuring the fair, stable, and effective implementation of tenant rights in the District of Columbia. She began her legal career as a law clerk in D.C. Superior Court and the D.C. Court of Appeals. Judge Puttagunta then practiced for several years in D.C., focusing on family and criminal law at a law firm and as a solo practitioner representing indigent defendants. Welcome, Judge Puttagunta. You may proceed with your opening remarks.
Thank you. Mr. Chairman and members of the committee, I am humbled and grateful to appear before you today as a nominee to serve as an associate judge in the Superior Court of the District of Columbia. I would like to thank each of you for considering my nomination and the committee staff for their hard work in preparing for today's hearing. I thank the DC Judicial Nomination Commission and its chair, Judge Emmett Sullivan, for recommending me to the White House. I thank President Joseph Biden for nominating me. I would also like to recognize my chief, Chief Judge Michael Spencer of the DC Rental Housing Commission for his unflagging support and encouragement, and Judges William Jackson, Todd Edelman, and Rainey Brandt of DC Superior Court for their mentorship and guidance. I would like to take a moment to thank my husband, Shiva Nagaraj. I would not be sitting here today without his patience, support, and encouragement. We are blessed to have two beautiful children, 4-year-old Anya and 6-month Taran. They bring endless joy and purpose to my life and inspire me every day to do good, to be better, to work harder. Being a mother and a wife is my greatest accomplishment, and I cannot imagine this journey without them by my side. I reserve a special thanks to the elders in my life. When my mother, Dr. Punnamma Kalapala, unexpectedly passed away when I was 5 years old, an entire community stepped up and supported my family so that I never felt the sting of such a loss. Many of you are watching this hearing live, and with you, I share all of my accomplishments. I thank my late grandparents, Visvesarao and Sitama Putagunta, who inspired me to go to law school. I thank Sashagiri and Sandhyarani Kalapala for sharing their home with me and my family. I am forever grateful for your guidance. I thank my in-laws, Krishnaswamy and Vimala Nagaraj, who are always so kind and so generous with their love. But above all, I thank my parents, Dr. Ranga Puttagunta, Bharati Ranga Puttagunta, and Dr. Punnamma Kalapala, for their love, sacrifice, and hard work. You have given me your everything, and everything, whatever is best in me that I have to offer, I owe to you. I care deeply about DC Superior Court as a forum where all parties are to be fairly heard. For many years, I worked in Superior Court every day. It is where I learned how to practice law. I have a profound admiration for the judges, the attorneys, and the staff of the court. I appreciate how committed the court's bench and administration are to serving justice. The judges I observed were patient, kind, respectful, and they went out of their way to ensure that even the most vulnerable litigant felt heard. They maintained fidelity to the law and issued rulings fairly and impartially. These are the values that guide me in my current role as an administrative judge, and if confirmed, I would uphold these values in Superior Court as well. My father grew up in poverty in India and came to this country almost 50 years ago with $7 in hand. He was successful and was able to provide for his loved ones. He is a shining example of the American dream. I was raised to be thankful for every opportunity, to value the ethos of hard work, and most importantly, to always give back to my community. This is what inspired me to pursue a career in public service, to spend hundreds of hours providing pro bono services, to represent indigent criminal defendants, and most recently, to serve DC as an administrative law judge. It is what inspires me to be here today and pursue this vacancy. Serving as an associate judge would be the ideal opportunity to use my skills and experience to continue contributing to the DC community where I have lived for over 14 years. Thank you for considering my nomination, and I look forward to answering any questions you may have about my qualifications.
Thank you, Judge Putagunta. Our next nominee is Kenia Seoane Lopez. Judge Seoane Lopez currently serves as a magistrate judge on the Superior Court of the District of Columbia, a position she has held for 9 years. She previously served as a bilingual attorney negotiator in the court's domestic violence division as an assistant attorney general for the Office of the Attorney General of the District of Columbia. Judge Seoane Lopez also served as a law clerk on the DC Superior Court earlier in her legal career. Welcome, Judge Seoane Lopez. You may proceed with your opening remarks.
Good afternoon, Mr. Chairman and members of the committee. I am honored to appear before you as you consider my nomination to serve as an associate judge for the Superior Court of the District of Columbia. There are many people I would like to thank today, without whose help I would not be here. First, thank you and your staff for the time and effort spent preparing for this hearing. Thank you to the DC Judicial Nomination Commission and its chair, Judge Emmett Sullivan, for recommending me to the White House. To President Joseph Biden for nominating me. Thank you to my siblings, Juan Jose, Wilbert, and Catherine for their love. Thank you to my Uncle Manolo and Aunt Carmen, who passed away a year ago, for paving my family's path to this country. Thank you to my large extended family watching in Massachusetts and Florida, as well as my friends in DC, for their faith in me and unwavering support. Thank you to my best friend and husband, Ronald, who often takes on more than his share of the parenting duties with a smile, which allows me to focus on my work. Thank you to my children, Gabriel and Natalia, for their willingness to share their mother with the families I serve. They are my source for inspiration and the impetus for everything I do. I was born in Cuba and was fortunate to come to the United States a few months before my 10th birthday. I can say with certainty that I would not be here today without the many sacrifices made by my parents, Eloisa and Jose Seoane. I will always be in awe of my mother, a woman from a small town in the eastern part of Cuba, who had the courage to dream a better life for her children, one that would allow them to be free and forge their own futures. My mother's dream propelled her to make decisions that set in motion a series of events that have brought me here today before the members of this committee. As my mother watches today from Boston, there is no doubt that this is the fulfillment of her American dream. Never in my mother's wildest dream would she conjure her youngest daughter being considered for a position where she's trusted with upholding the US Constitution and overseeing the application of the rule of law, which are the fundamental principles that compel her to bring her children to this country. I have dedicated my career to public service, hoping to give back to the country that has afforded me and so many others the opportunity to turn dreams into reality. I have spent the vast majority of my legal career in the DC Superior Court. For the past 9 years, I've served as a magistrate judge in the Superior Court of the District of Columbia. Before joining the bench, I spent the majority of my legal career in DC Superior Court, most recently as a bilingual attorney negotiator in the Domestic Violence Division of the court, and prior to that as an assistant attorney general for the DC Office of the Attorney General. The people who make up the court, from those who keep the floors clean and the lights on to those who rule from the bench, are my second family. For their kindness, support, friendship, and wise guidance, I am eternally grateful. I would specifically like to acknowledge Chief Judge Anita Josie Herring, whose encouragement and mentorship has been invaluable. Thank you again for your time today. If I am confirmed, it will be an honor and a privilege to continue to serve the residents of the District of Columbia as an associate judge of the Superior Court of the District of Columbia. I look forward to answering your questions. Thank you.
Thank you, Judge Seoane Lopez. Our final nominee is Sean Staples. Judge Staples also currently serves as a magistrate judge for the District of Columbia Superior Court, a position he was appointed to in 2013. Early in his career, he served as a law clerk on the Superior Court when he worked as a solo practitioner and an assistant public defender in Fairfax, Virginia. He went on to work as a clinical professor for several years, supervising law students representing criminal defendants in DC Superior Court. Before his current appointment, Mr. Staples held several leadership roles at Children's Law Center in Washington, D.C. Welcome, Judge Staples. You may proceed with your opening remarks. Mr. Staples, if you could make sure your sound is on.
All right, thank you. I wish to recognize and thank Chief Judge Anita Josie Herring for her leadership and support, our former Chief Judge Robert Morin for his leadership and guidance, former Chief Judge Lee Satterfield, who appointed me as a magistrate in 2013, and the committee staff for their work in preparing for this hearing. I am pleased to be joined by members of my family, my wife Mary Frances and son Sam, who are with us today, my mother and stepfather, Lila and Fred Hirschman, who could not be here today but are watching from their home in Florida, my family members, who are mostly public school teachers and government workers, instilled in me the importance of public interest work, I want to specifically acknowledge my Uncle George Habib, who not only encouraged me to be an attorney, but to also devote my career to public service. My family has been a constant source of inspiration and encouragement throughout my life, and it is beyond certain that I would not be before you today without their ongoing love and support. It is a great honor to be considered for associate judge on a court where I've worked for almost 30 years. I've been a magistrate since 2013, serving in family, criminal, and domestic violence divisions, where I presided over hundreds of cases in some of our most high-volume courtrooms. Prior to becoming a judge, I worked at DC's Children's Law Center, one of the largest legal services organizations in the city, and the only to focus on children. I spent 7 years working in the Guardian ad litem program, the last 2 as program director, where I supervised over half of the agency's 80-person staff in the representation of over 500 children per year in the abuse and neglect system. I was fortunate to clerk for then Associate Judge Robert E. Morin, who continues to be an invaluable guide and mentor. I've been an assistant public defender in Virginia, a sole practitioner, and a supervisor and clinical professor at the Law Students in Court program. It's an honor and a privilege to have served the citizens of the District of Columbia throughout my career. I am humbled by the opportunity, if confirmed, to be an associate judge and to continue to serve the community that I've been a part of for almost 30 years and that I care about so much. I look forward to any questions you may have. Thank you.
Thank you, Judge Staples. Start the questions. My first question will be to all of the nominees to answer this. The D.C. Court handles a very high volume of cases, as each of you know, and vacancies on both the Superior Court and the Court of Appeals have contributed to a significant backlog of cases. So my question to each of you is, if confirmed, how will you manage your caseload efficiently while also ensuring that each person who comes before you has a meaningful opportunity to be heard? I guess we'll start with Judge Putagunta, then Seoane, Lopez, Ms. Calderon, and then Judge Staples. We'll do it in that order.
Thank you for the question, Senator. It is certainly an issue that DC courts face, and I think the best way we can address it is to have judges who are experienced in the courthouse, familiar with both the law that's applied in DC, and who are able to hit the ground running. I think as a judge, the most important thing we can do is to resolve each case expeditiously, to recognize that we are bound by the law of the DC Court of Appeals and the Supreme Court, and to apply that to the law. I also recognize that not all cases need the same amount of time. There are some cases that can be resolved expeditiously, quicker than others, and we should resolve those. And that way we can leave time toward some of the cases that need more attention. But most importantly, I think, is to roll up your sleeves and get to work.
Thank you for the question. I have been on the court for 9 years now. Magistrate judges handle high volume calendars, and I believe that my last 9 years will be crucial, that experience in dealing with a calendar as an associate judge. Because we've been short-staffed, the magistrate judges have actually been called upon to actually be in other divisions which we were normally not serving. And now we serve in all the 5 divisions of the court. And we also have been very creative in trying to do the case management and calendar assignments so that every calendar is covered. So if I am confirmed, I will continue to do what I been doing for the last 9 years, which is to come to work every day, to work hard, to make sure that the docket moves, and to make sure that everyone is heard, and to make sure that I treat each case and rule fair and impartially in each individual case.
I was told to move the microphone closer. Can you hear me? Great. With respect to the Court of, a little closer? With respect to the Court of Appeals, Chairman, it is one, as you probably know, it is one of the busiest state-level courts of last resort in the country, and that's due in part to the 2-tier system we have in D.C. the judgments of the Superior Court are all appealed directly to the Court of Appeals without an intermediate court to serve as a filter. And so the backlog of cases, the heavy workload, is something I've given a lot of thought to. And you mentioned the vacancies. I think with Judge Thompson's retirement this month, the court will be down about 33% in active judges. But there are a couple of things that I will do. First and foremost, I will draw on my managerial experience from the Department of Justice, specifically my role as a deputy chief in the appellate section of the Civil Rights Division, where I had to juggle a high volume of cases along with my other management and administrative duties. I had to learn how to prioritize. I had to learn how to triage, so to speak, how to delegate tasks, how to supervise. And I think all of that will be directly helpful to me if I am confirmed to run my chambers. The other thing I can do, Judge Putagunta mentioned the importance of being able to hit the ground running on day one. And so I have been spending my time trying to learn as much as I can about the court and its docket and its procedures. And I will be prepared to hit the ground running on day one and seek the counsel of the fellow judges on the D.C. Court of Appeals who already have been so generous with their time and giving me tips and pearls of wisdom about how to work efficiently so that justice is not delayed.
So I would echo the comments of my colleague, Judge Seoane Lopez. Having been a magistrate for almost the last 8 years, I've had the opportunity to serve in many high-volume courtrooms, cover many different courtrooms in the same week, and have many responsibilities at the court. And I would continue to apply the skills I've learned in that work if I'm confirmed as an associate judge. I would also add that one way I think we can deal with the number of cases in our court would be to expand the role of magistrate judges. I know that there are some proposals to do that, and if magistrate judges are able to handle a slightly larger and different variety of cases, I think that would be helpful. Thank you.
Thank you to each of you for your answers. Ms. Calderon, you have served as an attorney at the Department of Justice for 20 years. Tell the panel here what challenges you anticipate facing as you shift from the role of an advocate to the role of an impartial adjudicator, and how are you preparing for that transition? You mentioned in your last question how you're preparing. Specifically, talk about that.
Certainly, Mr. Chairman, thank you for that question. Obviously, the role of advocate is very different from the role of an impartial adjudicator. That said, I think the role of advocate for the United States government is very different than the role of advocate for private parties. And as I mentioned in my opening, an express part of the department's mission is to ensure the fair and impartial administration of justice. And so I have that experience coming from the Department of Justice. We do take the rule of law very seriously. We have a unique responsibility as an appellate attorney, especially. You may know that most of the litigating components in the Justice Department have a separate appellate office, and that is by design. That is because appellate lawyers are obligated to take a fresh look, an objective look at the case when it comes to them on appeal, make a honest assessment of the facts and the law, and make a recommendation about what the government's position should be. And sometimes that does require an adjustment to the government's position. Sometimes it even requires a recommendation that the government confess error in a particular case. The biggest difference for me, and the challenge, of course, will be that once I'm on the Court of Appeals, if I'm confirmed, I will no longer have the department's institutional interests to inform my review of a case. I will have to put those aside. I've been talking to some of the current members of the court about this issue and how you have to really put aside sort of what you know and approach cases totally and completely neutrally and impartially.
Wrap up here. I have 3 questions that the committee asks of every nominee, and I'm going to ask each of you to respond briefly with just a yes or no. We'll start when I ask the question here with Ms. Calderon, and then Judge Staples, Judge Putagunta, and Seoane Lopez. So, first question, is there anything you are aware of in your background that might present a conflict of interest with the duties of the office for which you have been nominated?
No, there is not.
No.
No.
I think we didn't hear you, Seoane Lopez, push your...
No.
Second, do you know of anything personal or otherwise that would in any way prevent you from fully and honorably discharging the responsibilities of the office to which you have been nominated?
I do not.
No.
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 And lastly, do you agree without reservation to comply with any request or summons to appear and testify before any duly constituted committee of Congress if you're confirmed?
Yes, absolutely.
Yes.
Absolutely, yes.
Absolutely.
Well, thank you for that. Now, I'm going to now recognize Senator Langford, but before I do that, I'll be turning over the chair. We're in the process of voting at other committees, so chairing the committee, Senator Hassan will be chairing, but Senator Langford, you're recognized for your questions.
Thank you. Let me ask a question that I'll need just a brief answer from all four of you on this one. It deals with not only the backlog of cases, but also the delay in getting through the court system. It is exceptionally convenient for attorneys to ask for more time, to be able to show that I'm not ready. It's also exceptionally convenient for judges to say, we'll just reschedule you. It's just not convenient for the people that are trying to get justice and their day in court. It's also expensive for those individuals. So the backlog of cases seems to lead to more and more situations where it's just, we just weren't ready for today, so let's postpone this for a month or 2 months, and it continues to be able to bring one delay or another. My question to each of you is, what are you going to do to be able to manage your courtroom to be able to make sure that you don't have justice delayed in your courtroom and the people that came to get their day in court actually get their day in court? Judge Puttagunta, why don't you begin, and then we'll just take it down the road from there.
Thank you, Senator. I have two responses to that. The first is, I think it starts with me as the judge. I try to be as prepared as I possibly can be in my current role at the Rental Housing Commission. I go to court knowing the record, knowing the issues, having done research so that I can get to the heart of a matter quickly and ask the questions that determine the issue. The second, I think, is to work with counsel to set reasonable deadlines and then to have reasonable consequences if those deadlines aren't met. In my experience, having practiced in Superior Court, the judges that have those high expectations tend to have them met.
Judge Seoane Lopez?
Yes, I agree with Judge Putagunta. The way that I handle my calendar, I'm very clear at every hearing at the beginning what we are going to be accomplishing on that hearing. And right at the end of the hearing, we talk about what we'll be accomplishing at the next hearing and what needs to happen between the two. I think pre-trial conferences really give you an opportunity to figure out what the issues are and work them out before the trial date. I can tell you that I'm on a calendar right now, an abuse and neglect calendar, and there are statutory requirements for when trials happen within 105 days of removal, and we've been able to meet that challenge. We also have a very dedicated panel of attorneys that are appointed by the court. We have a review panel made out of judges who will yield complaints if an attorney, would usually ask for continuances needlessly, and the committee will address those concerns, and the attorney may no longer be on the panel to be appointed to cases, and so we take it very seriously at the Superior Court, and that has not been my experience. I believe that people are ready. I think I tend to agree with Judge Puttagunta that if the judge sets the tone of what has to happen and when, and you are very reasonable in the way that you approach your cases, and parties understand your expectations that the parties will be ready for trial when it needs to, or whatever the hearing for the day.
Be helpful. Ms. Calderon.
With respect to the Court of Appeals, I believe that deadlines and requests for extension of time are governed by the court rules, which require a showing of cause. And so if I'm assigned to a motions panel, I'll do my part to make sure we're applying that standard uniformly and consistently. I know from my own practice in the federal courts that if a circuit has a reputation of not freely granting extensions of time, attorneys tend to get started a little earlier on their briefs, and so that will be my approach.
Okay. Judge Staples?
I've experienced requests for continuances, and often they're about late-breaking matters, sometimes in criminal cases. I found that if I discuss the requests with the parties, often we're able to come to a resolution and continue forward in the case consistent with the defendant's constitutional rights. I am on one of the panels that Judge Seoane Lopez mentioned regarding the CJA panels committee. that decides who is able to pick up cases and who is able to remain on the panel, and an attorney's preparedness is taken into account with respect to that when I work on that committee.
Okay, thank you. Ms. Calderon, let me ask you a question. You're going to deal with issues different than what everyone else is dealing with on this, and you know that full well, and that there's some challenges just during the COVID time period that help us get a good feel on how the law would be handled by anyone. Mayor Bowser issued multiple orders declaring a public health emergency. Some of those resulted in the closure of all non-essential businesses or prohibited gatherings of 10 people or more. There was quite a bit of conversation about how that applies to faith-based entities, churches in particular, and what that looks like. So my question for you is, do you view houses of worship as non-essential businesses that can be prohibited from gathering?
Thank you, Senator, for that question. There were a series of decisions by the Supreme Court last year in the so-called shadow docket. And so if I am confirmed to the Court of Appeals, obviously I will have to follow any decisions by the Supreme Court that are binding on this issue. Whether a law that imposes restrictions, whether it's for a health pandemic or some other reason, whether those apply neutrally or impose a substantial burden on houses of worship, that's a very fact-intensive question. And so I would have to analyze whatever case that came before me in light of the facts of that case and the applicable Supreme Court precedent.
So, but dealing with stay-at-home orders, dealing with all of those things, there were times that there were stay-at-home orders, but there were exceptions on outdoor gatherings for tennis courts, dog parks, farmers market, and such, but outdoor gatherings were limited for churches and gathering. So would you at least agree that if a farmer's market can meet and a dog park can meet in an outdoor gathering, that a church should have no restrictions as well for an outdoor gathering, or at least the same, and make it consistent for all entities?
Yeah, I understand what you're getting at. My concern is that if restrictions were to be reimposed and a question like that were to come to me, I wouldn't want to be seen as having prejudged the situation. And of course, the law in that area is evolving. And so my approach, again, would be to let the facts and the applicable Supreme Court precedent drive the analysis.
Is there a difference in the eyes of the government between a church, a synagogue, and a business, and as far as their meeting and their operation? Should the government look at a church different under the law and how they gather to meet than they do at looking at a business, how they gather to meet?
Well, I believe the Supreme Court has said, obviously, that you cannot single out houses of worship. And so if there is evidence of that sort of discriminatory intent or motive, that is an important factor to take into consideration.
Okay, thank you. I will ask a follow-up question for the record based on our time and the ongoing votes that are happening, but I do have some interest on just the eviction moratorium that's happening. That will be in front of all of you in the days ahead to be able to manage the decisions and how you balance out the law. You have a unique responsibility to be able to balance out the opportunity for individuals who own, and there are quite a few in D.C. that own a single piece of rental property or a condo or something else that suddenly have no income for a year or two and are prohibited from gathering that in D.C., to also the responsibility to be able to help maintain good housing for those other individuals. So that is a difficult legal question, and I will try to submit that for the record for each of you and be able to follow up on. Thank you.
Thank you, Senator Langford. Senator Hawley.
Thank you, Madam Chair. Congratulations to the nominees. Thanks for being here. Ms. Calderon, if I could just come to you and pick up where Senator Langford left off a moment ago. In the case that he was referencing involving the District of Columbia and the prohibition on churches meeting in person, either indoors or outdoors, the United States District Court for the District of Columbia was sharply critical of the district, reversed the district's ban in a written opinion. Did they get it right?
You're talking about a decision of the district,
Right.
The D.C. Court of Appeals, not the D.C. Circuit.
I'm talking about the district court for the District of D.C.
But the federal district.
Correct. That's
Okay,
correct.
sorry.
That's correct. Yeah.
I have not read that opinion, Senator. But again, my concern with answering the questions, hypotheticals, is that if restrictions were to be reimposed and challenges were to come to me as a sitting judge on the D.C. Court of Appeals, I would want to assure the parties that come before me that I'm an impartial adjudicator.
To give me some sense then of how you perform the analysis, I mean, how would you walk through if the same restrictions were reimposed as existed in D.C. until the district court struck them down? How would you walk through the analysis?
Well, again, I believe the Supreme Court's recent decisions last year in what they call the shadow docket have changed the analysis a little bit from what it was before. And so I would want to study that very carefully to make sure I'm applying those standards correctly to the facts that are before me.
Give me your sense of what those standards are now as you understand them.
Before, I believe there was more of a requirement that you had to have evidence that the law had to not be neutral on its face. And now I think the court has analyzed some laws that appear neutral on their face, but maybe have a burden that on certain houses of worship. But I'm not as familiar with the decisions. I have not had an opportunity to address those issues in my practice. With respect to religious liberty, as you may know, the Civil Rights Division actually enforces a number of statutes that prohibit religious discrimination and promote religious liberty. So I do have experience under federal statutory law enforcing the Religious Land Use and Institutionalized Persons Act, as well as the religious accommodation provisions of Title VII. And so that's been sort of my universe of experience on religious liberty issues, and I do appreciate the importance of it.
Are you familiar with the Lukumi case from the United States Supreme Court?
This was yes, sort of. I believe it involved the free exercise of Santeria religion in Miami, but I don't remember enough about it to discuss it.
Here's why I ask. The holding of the Lukumi case is that even laws that appear to be and are formally neutral and generally applicable, nevertheless, if they uniquely burden a religious group, particularly a religious association,
yes,
whether that's a church or in this case not a Christian or Jewish congregation, but an entirely different religion, if they uniquely burden or disproportionately burden that religious entity, then they are unconstitutional. Now, that's been the law for quite some time. Lukumi is an old case now, so that's not I don't think you'd attribute that to the Supreme Court's docket. What alarms me about your answer a second ago is you said you think that the Supreme Court's moved the goalposts in its shadow docket. The rule you just described to me is the rule of Lukumi, isn't it?
Well, I'm not as familiar with that. I'm more familiar with the federal statutory standards under RLUIPA, which do prohibit an unjustified substantial burden on religion. That's what I know.
Right. Well, that's certainly true, and for my money, that ought to be the constitutional rule as well. But listen, I'll give you some of these questions for the record to let you to familiarize yourself, particularly with the district court's opinion in the D.C. case, which I think is a really important one. Let me just ask you about some of your political involvement, Ms. Calderon. You are one of the more partisan political records that I've seen for a D.C. Court nominee. I'm sorry. You're the acting deputy assistant attorney general in the Biden administration. You've worked previously for Senator Schumer. You've donated to Hillary Clinton's campaign, to now President Biden's campaign. You've also donated to some sitting Democrat senators in the Senate, of course, which is entirely your right to do. But here's my question. Do you think that parties who come before you can expect and anticipate and have confidence that you will be a politically neutral arbiter?
Thank you for asking me that. And I certainly hope so, based on my record of serving more than 20 years in the Department of Justice under both Republican and Democratic administrations. I joined the department through the Attorney General's Honors Program in 2001 during the Bush administration. I have now served more years under Republican administrations than I have Democratic administrations, and I am proud of all the work that the Civil Rights Division has done under both.
But let me ask you this: speaking of the Civil Division, the Civil Rights Division, it handles many election law disputes, including the department's recent lawsuit against the state of Georgia for their election laws. Were you involved in that case?
No, I was not.
Did you advise in a policy capacity in any way?
No, Senator. In my current role as an acting deputy assistant attorney general, I am responsible for reviewing the work of two sections that enforce statutes that prohibit employment discrimination. I've also been responsible for implementing the Service Members and Veterans Initiative Act of 2020, which was signed into law by President Trump earlier this year.
Let me ask you about the Brnovich case, Brnovich versus a DNC. Were you involved in that case?
I was not.
What do you understand the holding of that case to be as it would bind you?
Senator, voting rights has not been an area that I have focused on.
Have you read the Brnovich case?
I did skim it when it came out, correct?
So what's your memory and understanding of what you would be compelled to follow according to Supreme Court precedent?
Well, again, that voting rights is not in my current portfolio.
Are you telling me you're not prepared to adjudicate voting rights disputes? I'm not sure what to make of this answer. Are you not prepared to adjudicate these? You're just saying that you didn't prepare for today.
No, I'm saying that voting rights is not in my current portfolio. It is not something I have focused on the last few years.
And so you're not prepared to answer my questions about it?
No, I'm happy to answer your question for the record.
I'm noticing a pattern here. I mean, you're not answering my questions on voting rights. You're not answering them on religious liberty. You're asking for a very important judgeship, but you're telling me you're not familiar with large swaths of the law. And I understand that you're under oath here in front of cameras. I'm sure you were advised not to answer questions, but can I just tell you that it's very hard for me to evaluate your record on these issues, your positions, if you're telling me that you're not familiar with large portions of very important law, including Supreme Court cases, including Supreme Court precedents that are quite old, frankly, and venerable, that you apparently have no memory of, and in the case of Brnovich, Supreme Court cases that are quite recent and important that you say that you're not familiar with. That's a big concern for me.
Well, Senator, I am aware of those decisions.
Good. Well, tell me what you think they mean then and how you're going to apply them.
I'm aware of the decisions. I understand Brnovich involved Section 2 of the Voting Rights Act.
Good.
I know that it involved an Arizona law. I don't know enough about it to speak with you about it at this time. My approach as a generalist in the appellate section has been to get up to speed on the area of law for the cases that are before me at the time that they are before me.
Well, listen, I'll give you these questions for the record. I just have to tell you, I sit on the Judiciary Committee. I'd be less concerned about this if this weren't a consistent pattern. You are very clearly a very accomplished attorney. I mean, there's no doubt about that, and extremely capable. I mean, there's no doubt about that. So I just don't believe that it's not a matter of you not being familiar with case law. My guess is you have an incredible mastery of huge bodies of case law. I suspect you're advised not to be prepared on these issues so that you could just say that you don't know and you can't answer the questions. I just submit to you, I think that that's unacceptable. So I'll give you these answers, these questions for the record, but I have to tell you, based on what you've not told me here today, I'm really, really concerned. Thank you, Madam Chair.
Thank you, Senator Hawley. Senator Portman, you are recognized for your questions.
Thank you, Mr. Chairman, and thanks to my friend, James Langford, for his role today as the ranking member. There was a little discussion earlier about crime, and there is a crime wave in D.C., as you know, and it's not only in D.C., it's happening around the country, particularly in some of our bigger urban centers. According to the crime statistics, assaults with dangerous weapons, homicides, and armed robberies are all on the rise. Armed robberies are actually up 22% from last year. So 22% increase in armed robberies this year as compared to last year. And last year was a concerning year, as you know. The DC chief of police has recently criticized the DC court system for contributing to the rise in crime, accusing the court system of allowing criminals to roam free. And I can give you a citation to that, but that was his concern. To our DC Superior Court candidates here, our nominees in particular, what can the court system do to address this crime wave and to avoid what the chief of police at least believes is part of the problem? And what other ways would you recommend that the court work better with the prosecutors and with law enforcement to reduce crime?
So, Senator, this is Sean Staples. I'm sorry, I don't know what order we were supposed to go in.
Excellent. I'll let you go first. Since you started talking, that's great. But I'd love to hear from all three of you. Thank you.
I think the court and all of its partners in the criminal justice system are acutely concerned about the rise in violent crime. But I can tell you as a sitting judge, we have to look at these cases very, very carefully and decide them as fairly and as impartially as we can. We have a Criminal Justice Act committee, a C10 committee that meets twice a month that discusses the operations of the C10 courtroom that includes all of our partners from the U.S. Attorney's Office, from the Attorney General's Office, from the Pretrial Services Agency, from MPD, and from the Department of Corrections. and that discusses how that court functions appropriately. But the bottom line for me as a judicial officer is to look at these cases very carefully and decide them on a case-by-case basis as carefully as I can.
Others?
I'm happy to
Ms.
start.
Lopez?
Sorry.
Go ahead, Judge Lopez.
Yeah, so I agree with Judge Staples. I believe the court does have a good track record of working with stakeholders. They're in every committee of the court, including those in the criminal division. And the way that we can address that issue is to again, roll up our sleeves, get to work, rule on our cases expeditiously and in a fair and impartial manner, while actually working with our stakeholders to improve the administration of justice, which we aim to do on a regular basis. But I do agree that the court is actively working on that. I think COVID has provided us an opportunity to kind of do a wholesale approach of a review of all of our operations. And we have been doing that, to kind of figure out what's the best way to go forward in terms of using the technologies, and those conversations are in play about how we can expeditiously, deal with the cases that are before us. Unfortunately, the judge's role is very limited in the cases that it sees, and so our work is just to make sure that those cases are heard quickly and expeditiously, and that we have certain trial dates, which we are working on, and continue to work with our partners to make sure that we are doing the best that we can within our confines to address the issues.
Thank you,
Putagunta?
Senator. Thank you, Senator. I echo the sentiments of my fellow nominees. As a judge, I believe it is most important that we faithfully apply the law, the statutes created by DC Council, the law created by the DC Court of Appeals and the Supreme Court, and do that as faithfully as we can to each set of facts that come before us, and to ensure that it is fairly and impartially and consistently applied. And I also agree with my fellow nominee statements that keeping open lines of communication with stakeholders, MPD, the defense office, the prosecutor's office, and evaluating operationally how the court is functioning and what we can do to help address this is also appropriate.
Well, those answers are fine. I guess what I didn't hear in any of the answers is that you have any new ideas to deal with the crime wave, except that you'll apply the law fairly and expeditiously as possible. And by the way, the backlog, as we've talked about earlier, is a huge issue too. The mayor has talked about that. She has criticized you guys because she cited it as a public safety concern in terms of the backlog. I say you guys, I mean the DC court system. So let me just ask a more general question. Are you concerned about crime in DC? And is that something where, as a judge, you feel like, you have a role to think about sentencing and think about, how to deal with it? There's obviously been not just increased crime, but also, increased drug use and drug overdoses and drug overdose deaths. The issue of illegality is one that has grown, and I think the courts do have a role to play here, not just to apply the law fairly, but to look at this from a different perspective, perhaps. So let me just ask you that generally. Are you concerned about the crime wave, and do you think the court has a role to play?
So I will start again. I think
Mr. Staples, we'll start with you because you started before.
Thank you. I think, as I said, all of the agencies that work in this criminal justice sphere are concerned about crime. But in terms of, I think often as a judicial officer to discuss these issues often wades into policy concerns about what we do about them, what we do about the issues regarding crime. And I do believe it's my role. It's really just to listen and to really focus, however, and listen to the cases that are before me with a heightened focus to be able to deal with these issues effectively.
Okay.
Yes.
Well, my time's about expired, but I would just refer you to the concerns of the DC Chief of Police and the Mayor of DC, both of whom talk about, the mayor talking about public safety, given your backlog and the concern about getting, the bad people off the streets, and then the chief of police talking about the court system too often letting criminals roam free. I hope that should you all be successful in your confirmations, that you will consider those concerns and consider your responsibility in trying to address those. So thank you, Mr. Chairman.
Thank you, Ranking Member Portman. The nominees have filed responses to biographical and financial questionnaires. Without objection, this information will be made a part of the hearing record with the